A contract can be verbal, it can be written, or it can be by conduct. You have the same rights as that of a person who has a written contract. Hi guys, welcome to Ask a Lawyer segment by Crime Sipoa. I'm Praxedes Kageha, an advocate of the High Court of Kenya with 3 years experience now, post-admission. I work for MMS Advocates. I'm an associate advocate. We are a team of lawyers who generally deal with conveyancing, commercial work, litigation, and we also do policy review and policy regulations. So today we are here to talk about employment contracts, which is one of our main areas of specialization as a firm, and we've posted content on our website and also on our YouTube channel. But for today, we are going to be narrowing down on some of the questions that we've been asked. And so I'll move on to the first question. My employment contract states that I should put in 42 hours of work per week, but I end up working 48 hours and yet I'm offered no overtime pay. How do I lay a legal claim to this? Well, this happens most of the time where you have a set salary, and the Employment Act actually states that your pay should be itemized. Now, there are those of us whose pay slips are itemized, and there are those of us whose pay slips are not itemized. So it therefore makes it difficult to ascertain from the amount of salary you're paid how much is for what, because ideally you're supposed to be receiving your basic pay, you're supposed to be receiving your house allowance, and then the rest of the allowances come in now for, in this case, for overtime or public holidays. Yeah, that is extra pay. That is something that was not foreseen. It just happens that during the month you worked a bit more longer than what you were supposed, the time you're supposed to work. So what happens in most scenarios, you can lay this claim after you leave that place of employment, because when you claim before, okay, you can attempt claiming before. The challenge with claiming during your time of employment is that it can create some bad blood. However, if you have a good rapport with your boss, you can just raise the issue, make it formal, send an email or do a letter, notify them of the time you worked overtime and request for them to pay, but don't fight too much, because of course now once you fight too much, then of course your boss will fire you. So the best is, if you attempt claiming the overtime pay during the your employment period and it is not received well, it is okay. You can wait till you're terminated, because there's room for such, and such claims are not they are not limited by the Limitation of Actions Act, because somebody would ask, okay, well, I've worked for over 6 years or over 10 years. What happens to the overtime that accrued on my first year of employment? This is 10 years past. You can still claim for that. The laws allow you to do that. So yes, if you have a good rapport with your boss, ask for it before. And if it is not received well, don't push too much unless you're willing to lose your job. So yeah, I'll move on to the next question. My employment contract states that I have the discretion to decide whether I take my 21 leave days as spread out through the year or all at once during a specified time of the year. However, when I try to spread out my leave days, my boss explicitly refuses. What should I do? Well, the law does not specify when you should go for your leave. It just specifies the amount of time that you are supposed to go on leave. Now, we all work in different workplaces, so therefore it's difficult to say that now take it as one, combine the leave days or spread them out, because as well, if you were to spread them out and there's work to be done, well, who do you want to fulfill that work on? Or unless your boss has room to bring in someone else to replace you once you go for leave, and then now when you come back you pick up your duties. So it's okay for them not to allow you to spread them out, or not to allow you to take all the 21 days at once. The most important thing is that you need to make sure that at the end of the year you have attended to all your leave days. However, if it still proves impossible to get all your leave days, you can claim for that. You can claim for unpaid leave, yeah, because the act is clear that if you don't attend to your leave, then you need to be paid for in lieu of that leave. So where you don't attend all your leave days, don't be afraid. Just, it's okay, so long as you make sure you've claimed, and maybe it's on paper, get it documented, because the challenge we face with this is that normally there's no proof that somebody requested for leave or what. So always make sure you leave a document trail of your requests and your efforts to try and get this done. Yeah. So once you've done that and it still proves impossible, just like the overtime, you can't push so much when you're still there. You need the job, yeah? So you can wait till when that employment contract is terminated. Then when you claim for pay for the days you never attended to your leave. So yeah, I believe that's well understood. So the next question is, I have been working at the same organization for the past 6 years under an oral contract. Recently, I found out the company is advertising my position, so I may be laid off. What action is available to me? Well, normally there are different kinds of contracts. This is a merge of contract law and employment law. A contract can be verbal, it can be written, or it can be by conduct, because there are times where, I call you, I tell you I've employed you. That's an oral contract, yeah. There are times where you come to my office, you work the first day, you go home, second day, first week down, second week down, third week down, fourth week down, and I pay you at the end of the month. You see, that's an implied contract. Either way, it's still a contract. Yeah, even if you work for one day and go home and I pay you for that day, you've still worked for me. You are my employee for that day as a casual, yeah? So it's still a contract, and therefore you have the same rights as that of a person who has a written contract. All your rights are due for as long as you can establish that both parties, in this case being the employer and the employee, have behaved in a manner likely to suggest that there's that employer-employee relationship. Then you are an employer, you are entitled to all the rights of a normal employee under the Employment Act. This is a looming redundancy case, yeah, for lack of a better word, because if you're looking for someone else to come do my job, it means you'll either demote me, you'll either promote me, or you'll fire me, yeah. So I can say the question is more of speculative. You wait till the company makes finishes what it has started. Because if they've just advertised, well, you don't know what they're going to do with you. So you would rather wait for the end. If they end up terminating you, well, you are entitled to claim for unfair termination because there was a contract. And as I had said earlier, you are entitled to all rights as a normal employee under the Employment Act. Yes. So the last question on this is, I gave my employee a paid study leave to study abroad. They went abroad but never undertook any studies. I terminated the employment. Can I press any charges to get my money back for the months that I was paying them? Okay, normally this arrangement, we call it a bonding arrangement. Bonding, just taking its simple meaning of bonding, where we agree that I'm allowing you to do this, but in return you have to do this. So it is advisable for both parties, especially the employer, that you sign a bonding agreement whereby you clearly, it's a contract like any other. You state the terms. You say this employee is going to study at this particular place for this particular period of time, and in return I'll pay them as usual. They're still my employee, and at the end of that period there are two options. Either you come back and work for me for a specific period of time to recover the time lost, or you pay a certain amount of money. So these things are better off negotiated before. Let it not be a casual agreement. So in this case, where that employee is bonded to you, or you as an employee, you are bonded to your employer for a particular period of time, when either of you thinks of terminating that bonding agreement, then you need to be ready to pay in lieu of the amount that you had agreed. So yes, I would not use press charges because that is criminal. This is more of a civil claim, I would file a suit to recover the money that I was supposed to have gotten in case that employee doesn't come to work for me. So thank you so much for listening to me today. I'm hoping that I've been able to be of help. However, as earlier mentioned, we have articles on our website, and there's room for you to even post more questions, or on the Ask a Lawyer segment by Crime Sipoa. You can reach out to us through either avenue. So thank you so much, and bye.